Mr. Murdoch, let me just ask you again. Did you mislead this committee in your original testimony?
No, I did not.
So if you didn't, who did?
As I've written to you, and I've said publicly, I believe this committee was given evidence by individuals either without full possession of the facts, or now it appears, in the process of my own discovery and trying to understand as best I can what actually happened here, it was economical. I think my own testimony has been consistent. I've testified to this committee with as much clarity and transparency as I possibly can. And where I haven't had direct knowledge in the past, since I testified to you last time, I've gone and tried to seek answers and find out what happened and where the evidence is and what's there. And that's what I'm here to do.
So was it Mr. Crone, a respected lawyer and in-house legal advisor for many years?
Who did what?
Who misled this committee?
As I said to you, as I wrote to you and I issued a public statement, certainly in the evidence that they gave to you in 2011, with respect to my knowledge, I thought it was inconsistent and not right, and I dispute it vigorously.
So you think Mr. Crone misled us?
That it follows that I did, yes.
And so do you think Mr. Myler misled us as well? I
believe their testimony was misleading, and I dispute it.
Do you think Mr. Pike, a partner at Farrelly, the solicitor to the Queen, misled us in his recollection of events?
I don't have a reason to believe that, nor do I have direct evidence otherwise.
The last time you appeared before us, you said at question 155 that the critical new facts as the company saw them only emerged from the civil trials at the end of 2010. Is that right?
To my attention, that is correct, yes.
But we now know that this statement was completely untrue. We know that critical new facts were seen by the company as early as 2008. So who told you that it was only in 2010 that the company became aware?
Well, certainly I became aware of those critical facts in 2010 after the due process of the civil trial had uncovered some of the police evidence and discovery by those civil claimants.
And who was it who told you?
I think
was it
previously I had received assertions from Mr. Myler, from Mr. Crone that there was no new evidence, and that, you know, as you had received those assertions as well in 2009 and later.
So you also said that you sympathised with the frustration of the committee, and you said it was, and I quote, "a matter of real regret that the facts could not emerge and could not be gotten to my understanding faster." You now know that that was untrue. You could have known.
It is a matter of concern, and I think what I've tried to describe earlier with respect to sort of how I think about what we could do differently and how we can improve and what happened here. I think the amount of transparency between what was known by certain individuals, or at least what was seen by them, the leading counsel's opinion, etc. If that had been more transparent to me, I think that would have been very, very important and very helpful. But it was not, and that is a matter of great regret.
So the correct position is that the facts emerged in 2008 and this committee was misled?
The facts did not emerge in 2008. Certain individuals were aware. The leading counsel's opinion was there. The Fort Neville email, so-called, was there. None of those things were made available or discussed with me, and I was not aware of those things. And even in 2009, when the newspaper made allegations about those things, the company relied, and I've testified to this fact and written to you, and I'll say it again, the company relied for too long on repeated assertions and assurances as to the quality and rigor and scope of the internal investigations that have been carried out previously, and I think relied also on the assertions and reassurances made publicly by the police, who had all the relevant information that no new evidence was found within 24 hours of the 2009 allegations, for example.